Okay, welcome back. We're going to get started with our next speaker, and it's a good one, too. I'm sure that with aging comes a lot of questions about legal issues. Luckily, we have an expert here with Mid-Minnesota Legal Fund and the Senior Law Project. Please welcome Chris Klimpel.
All right, so I wanted to introduce myself. My name is Chris Klimpel. I am actually a paralegal, a legal assistant with the Senior Law Project in St. Cloud. My supervisor, Carla Kruger, is ill, and so I'm sort of a stand-in for her. But we wanted to be able to keep this and share this information with you all so that it felt like the right thing to do. So I always tell people when I talk to them and they call us and said, you know, I'm kind of like the nurse that you talk to before you talk to the doctor, because I'm not an attorney. So I can't give you legal advice on the call, and I can't give you legal advice today either. But that said, what I'm going to talk about are things that are underpinned in law, but they're very practical tips that you'll want to know as you are navigating life, taking care of people with dementia, and also anybody age 60 and over. A lot of people have experience going to the doctor, but they don't necessarily have experience talking to an attorney. And it's a very frightening sort of thing. So I just kind of want to break down that barrier and just say that we are a very friendly audience at Legal Aid, and so hopefully you'll be friendly with me too. So Legal Aid, oops, I didn't even advance the slide here. That's what I wanted to say. There we go. So Legal Aid for Older Minnesotans. We're known as the Senior Law Project, and we're under the umbrella of Mid-Minnesota Legal Aid. So Mid-Minnesota Legal Aid serves people of all ages, but in particular for people age 60 and over, we do not screen for assets or income. So, and that is because well, I'll back up. Legal Aid itself is a nonprofit. We are not with the county. We're not a public entity. We have a variety of funding sources. And we have offices in St. Cloud, Wilmer, and Minneapolis. And I'm talking to you from the St. Cloud office. We offer free legal help with civil cases, so no criminal cases. And I tell people, you know, we think of the Constitution and we say, well, if you are accused of a crime and you can't afford an attorney, one will be appointed for you. Well, that works if it's a crime. If your landlord wants to evict you, that's not criminal law, that's civil law. That's landlord-tenant law. And there's no guarantee that somebody is going to be appointed to represent you in court against your landlord. So that's the illustration I use. That's where Legal Aid steps in. The income restrictions that apply to people under age 60 do not apply to people age 60 and over. That's the beauty of the Senior Law Project. That said, and so the funding that, specifically the funding for us comes through the Older Americans Act, and it funds this. And particularly the Central Minnesota Council on Aging provides our funding. We don't have enough money to serve all seniors in all 14 counties for all of their legal problems. We wish we did, but we don't. So our focus is going to be on people who have the greatest economic and social need. That said, I always tell people, if you're not sure, give us a call, because we do more than, we always like to try and give resources and advice, even if we're not able to fully represent. And you can see I would call it the legalese that's up there. The slides are the ones that Carla put up there. So I want to give a shout out to the Council on Aging for funding us to be able to do this work. So diving into the Senior Law Project. Who qualifies? As I mentioned, people age 60 and over. And if you are the legal representative of somebody age 60 and over, you yourself do not have to be 60 and over if our client is the senior. Our service area is 14 counties in central Minnesota. So from Cass County to Wright County, and from the western edge of Stearns County, all the way over to Pine and Chisago counties on the Wisconsin border. I was going to make a map, but I didn't get that far, so that's what we've got. And it's hard to see up here, but when we say what kind of legal problem, I'm going to dive in and give some examples of the kinds of problems we can help you with. Listed up here are housing, public benefits, social security denials, debtor rights and consumer law, power of attorney and healthcare directives, immigration, and other areas. Those are sort of the highlights. So what kind of help? Those are the areas of law. So what sort of help can we offer? We always offer advice, and that'll include written advice with a letter to follow up on whatever it is that I've talked about with the client after discussing the situation with the attorney. We can also offer what we call brief service. These distinctions might not make a big difference to you, but I'm just trying to illustrate the kind of help we can provide. A brief service might mean that we need to contact the agency on behalf of somebody. We might need to contact the county. We might need to contact the landlord. We have to reach out to somebody else on behalf of the client. We might help them fill out a form so that they're successful in getting the next step processed. We also can provide representation in court if it comes to a court action or in administrative hearings. And the administrative hearing part is where I think you may say, well, what does that really mean? Well, if you have a dispute or a denial with the Department of Human Services, Minnesota DHS, or the Social Security Administration, or the HRA, the Housing Redevelopment Authority, those are all legal administrative hearings. And it's really good to have legal advice or legal representation before facing down any one of those. And then also referrals. If we are not able to help or it's not something that falls within our priorities, we like to try and give referrals either to attorneys in private practice, either attorneys in private practice or a network of volunteer attorneys, depending upon the person's income and asset levels. So when you call legal aid, what can you expect? The first thing is that it needs to be a call, and the person who is doing the calling needs to be the client or a representative of the client. So we can't take a call on behalf of somebody else and give advice. It has to be that person making the call. That said, if you've got a loved one who is not in a position to be able to make a phone call about a legal question, if you are the legal representative or if you have permission, and that permission is given over the phone or explicitly to us, then we can go ahead and work with your representative. But we can't just answer questions about a third party. We schedule an appointment, but if there's an emergency, if there is a timetable, there's a deadline, there's a hearing or something coming up, we can handle those outside of the appointment schedule on a timely basis. So start with a phone call, schedule an appointment, or get an emergency appointment. We do appointments, this is not on here, but we do appointments in person, and we also do them over the phone. And in some cases, we will also do home visits, if that's really what it takes to get it done. We provide interpreters in all languages. Our staff actually, we have in-office staff that are fluent in Somali, Oromo, Spanish, and Vietnamese, as well as English. But for other languages, we serve everybody. We just need an interpreter on the line. And then finally, the client or legal representative must be able to direct the representation. And this comes into play when we're talking about people who may have some diminished capacity. So direct representation means that the client can tell us what they want, or the representative can. So they need to be able to it doesn't have to be complex legal understanding, but that person needs to be able to make decisions about how to proceed with a matter. If we should we make an offer? How should we respond to a proposal? Should we start a lawsuit? We get a counter offer from the other agency. Should we accept it? Should we move forward? Those kinds of questions. I can tell you that we're really skilled in helping people be able to advocate for themselves, but the client does need to be able to direct us in their representation. Okay, so the kinds of cases that we handle, and I'm going to use this part after talking through with Carla, my supervisor, to try and give you some stories and some illustrations about the kinds of cases we've handled, how we've been able to help with an eye towards people who are caring for loved ones that have dementia or other similar issues, or just anybody, honestly. So, as I mentioned in the beginning, the ones we're going to focus on are housing, public benefits, advanced directives, consumer, and family law. So, some examples. What kind of housing law, what kind of cases do we help people with? A big one, a really big one, is considered a reasonable accommodation. So, federal law requires reasonable changes to rules and policies that enable a person to continue to use and enjoy the premises where they live, their home, their apartment. Some examples of this are if somebody lives in an apartment and they have, it's subsidized. They're on limited income, so they pay a limited portion of their rent, and the rent is calculated based on their income. It's possible to get a live-in aid and have that live-in aid not be on the lease and have their income not count toward the income of the household. So that's a way of modifying the rules for housing to enable someone to get an accommodation to be able to have this live-in aid because of their disability. Another example of accommodating a disability, we had a client who owned a townhome, and the townhome association did not want to permit him to install a wheelchair lift on his front stoop. Now, because the townhome association wanted everything to be uniform and they didn't want anything to be changed. And we went to bat for him and said, this is a reasonable accommodation. Federal law requires that policies and procedures need to be changed to reasonably accommodate the needs of somebody to be able to continue to use and enjoy the premises. And so that's what we did. Now, that gentleman paid for the lift himself, but he was able to get it installed in his townhome. Another example is to not use certain behaviors to evict a person. So, for example, we had a client who had obsessive compulsive disorder. And part of his disability was to get agitated and obsess about certain things. And he would continually ask the landlord about what he was worried about, and then he was worried about again and again and again. And his landlord the building manager started to perceive this as hostile and even threatening. But it was his disability. So what we did is we worked with the client and the landlord, and we made a plan, also with his doctor. And what we came up with is that this individual was going to put his complaints in writing, as many as he wanted. But he agreed not to complain to the landlord in person anymore. And he was able to stay. So if he hadn't done that, his behavior may have been enough for the landlord to say, look, you need to be out. That said, I will say that the person needs to otherwise be lease compliant. They need to be paying their rent. They need to be doing all the other things they need to do. But you can't use certain behaviors as a result of a disability to evict. Another example, I had a client who had a beloved pet, and she had dogs her whole life, and she was struggling to get around physically, and at night when it was really dark, her vision was poor. She was not able to always get the dog out to go to the bathroom, so she was using those pee pads. And the landlord had a policy that said no pee pads. You're going to have to move. And we went round and round, and she came up with a plan that for the most part, she had found another neighbor to help take the dog out, but in an emergency, she could use a pee pad. She got to stay. So those are a few reasonable accommodation success stories, things to think about. The other two parts are assisted living contract termination and nursing home involuntary discharge. Both of those are also related to housing. The protections for nursing home, the protections against involuntary discharge from nursing homes have been in place for a long time. Similar protections for people who are in assisted living just went into place in, I think it was 2021, something like that. I'm looking around. So essentially, there was a process created by the legislature that provides a really significant level of protection before somebody is discharged from assisted living. The facility just can't simply terminate their lease anymore. Oftentimes, the person will end up agreeing to move because of there's something about the situation that is not workable, but only after the facility has found a place that's suitable to meet the client's needs. So there needs to be an orderly process to transition from one assisted living to the next place. And the person gets to stay until the new place is found. However, I would tell you that that process is a lot easier to handle if you have someone with legal expertise advising you. Another example was we had a client with advanced dementia, and the facility had terminated his contract, and his wife was despondent because she knew that she wasn't going to be able to take care of him. We appealed that and discovered that the facility really, when digging into it, the facility really hadn't done everything that they could to meet his needs. So eventually he did move to a different facility, but he was not rushed out and did not land on his wife's doorstep. He landed, it was an orderly process. So in the meantime, the facility looked harder at what they could do to meet his needs. And Carla would have me tell you that our success rate in getting an amicable resolution to these situations is pretty high. So, okay, so that was all housing. I'm going to turn the page slightly and talk about some examples for public benefits. So when I talk to people in general, I just say, you know, if there's something in your public benefits that you don't understand, the process to appeal it, to challenge it, is often it gets to be a legal process. So when in doubt, just give us a call. In particular, I want to point out something, the Medicare observation status. So this has to do with Medicare benefits, and specifically Medicare covering nursing home stays after a hospital visit. So most important thing for caregivers is to advocate early if your loved one is hospitalized. A lot of times people come in during an ER visit or something like that, and they say, well, we're going to take you to a room. Well, that room, the person is going to be admitted either for observation or as an inpatient. And the consequences of whether they're admitted for observation or an inpatient are legally important, because if that person then goes to a nursing facility following their hospital stay, they must spend 3 days in the hospital as an inpatient. Observation doesn't count. 3 days as an inpatient, otherwise Medicare will not cover the nursing home stay following that hospital stay. And we get people that come to us with an explanation of benefits and a bill months after the hospital discharge, and it's really late to do anything about it then. It's important that you advocate for your loved one while they're in the hospital. They should give you a form that says, when they're admitted, that says whether they're being admitted for observation or inpatient, and you can ask about it. And if it turns out that they are admitted only for observation, we suggest that you reach out to their doctor and primarily the doctor, and advise of all the conditions that a person needs to have it be monitored, so that they can, if it applies in any situation, to have them admitted as an inpatient. Now, the doctor's not going to make stuff up. That is true. But making sure that you don't just glide over the admitted part and then discover that this nursing home stay, that you should have advocated more thoroughly or asked more questions at that time. I can only imagine, I personally haven't had to do this, so I can imagine all of the things that are going through a caregiver's mind when they bring somebody in to the ER for a health emergency. But that one thing is worth checking on. If you get the explanation of benefits back after the fact and you get this bill and you want to challenge it, we can still call us and we can still say, we'll look into whether or not everything was done properly. But the takeaway here is advocate early. And then the next thing is the elderly waiver. And an elderly waiver is a Minnesota term for a person who's able to get, many of you are probably familiar with this, they're able to get the same services that you would get in a skilled nursing facility, but instead of living in a nursing home, those services come to you while you're at home or in an assisted living facility. And some of those things include getting a PCA, personal care attendant. So, pardon me. A personal care attendant helps with bathing, dressing, grooming, light housekeeping. An elderly waiver can also pay for things like grab bars or durable medical equipment. So think of things that you would get in a nursing home that aren't available at home or in an assisted living facility. And then on top of that, there is a program called the Consumer Directed Community Support. And that essentially takes the money that would have been simply used to hire a PCA by an agency or a social worker and gives it to the client so that they can hire themselves. They can hire a family member to be their PCA. So those are some things inside of the elderly waiver. We help people fill out those forms. We can answer questions about the elderly waiver. To qualify for the elderly waiver, there are income and asset guidelines, but I just wanted to let you know that that's a program that's available, and it's one that we assist people in getting. A public benefit, if you will. Advanced directives. So we provide home visits to do powers of attorney and healthcare directives for people. I don't want to take the thunder of the attorney who's coming next, because there's a lot more to estate planning than what legal aid provides. We intentionally don't do things like wills, trusts, real estate, things that private attorneys can earn money from, and focus on those services that are for the most economically and socially needy people. That said, a power of attorney is an incredibly important document for somebody who may need someone else to act on their behalf, control their, it gives the attorney, in fact, has the power for legal, financial, and business affairs. Bank accounts, checking accounts, public benefits, veterans benefits, insurance policies, you name it. Not having a power of attorney, and I'll back up, and having a power of attorney in place is a double-edged sword. It gives the attorney, in fact, a lot of power, but it also can be done quickly, and it can be written so that it survives after a person loses capacity. Once a person has lost legal capacity, they cannot sign a power of attorney document and give that power to anybody else. At that point, we're then faced with something like guardianship, although that's above my pay grade. So that's power of attorney. The limitation on power of attorney is that it does not have anything to do with a person's medical or health care. That is in a separate document called a health care directive. And that essentially does one or two things. The first one is that it names a person who is the healthcare agent to make medical decisions when a person no longer has the ability to do so. So the healthcare directive is geared to only after a person is unable to communicate or make decisions. You name the person, and or you can outline. Our form has half a dozen pages to talk about what kind of care, what gives me comfort, who should be my doctor? These are the things I want. These are the things I'm afraid of. Under no circumstances do this. If at all possible, do this. It's not a legalese form. It's a very thoughtful form that allows you to have a conversation with your loved one or just to think about what it is that you want to do. And then committing that to writing and getting it notarized is an important planning step. Did I say that we also do home visits for that if necessary? Yes. Either. But I'll repeat the question. With the healthcare directive, she asked, does it have to be notarized or can you have 2 witnesses? And thank you. You can also do it with 2 witnesses. I'm a notary and I'm deputized to go through the form with people. It's reviewed by our attorney. So sometimes it's easier to just call us because we can get it done all at once without having to hunt down 2 witnesses. That said, social workers and other providers here are incredibly skilled at implementing a healthcare directive in a lot of different situations. We do not have a monopoly on healthcare directives and powers of attorney. Yes. I'm sorry, I didn't hear you clearly. Yes, you can also ask about a healthcare directive from your primary physician. As I said, we do not have a monopoly on these tools, but we do provide them if that's something that you want. I encourage everybody to check into them. Okay. As one comic said, and now for something completely different. Some consumer case examples. One example is long-term care insurance. A lot of people buy long-term care insurance, and then when it comes time to use it, it's denied. And people say, well, what in the world? Give us a call. We will review the denial and determine whether or not it was denied appropriately or not. And oftentimes, it's just an information gap. The insurance company needed really specific information about eligibility, boxes that needed to be checked that they didn't have. So we facilitate getting that information and provide the information and then are able to challenge the denial. So facing an insurance company denial is not a fun thing, and we're here to help with that. I actually think it's kind of fun, but that's just because I like fighting for the underdog. Debt collection and garnishment. So many people who are on fixed incomes find that they put a medical bill or on a credit card and are going to chip away at it little by little. Or they may have employment and they put some expenses on a credit card and they're keeping their head above water. But then something changes and they aren't able to work anymore. And what ends up happening with credit card debt is that it often you get a few collection letters from the credit card company, and then it gets sold to a collection agency. And then if it goes again, it will be, eventually the creditor is going to turn it into a lawsuit, and a person will get a summons and complaint, and then eventually a judgment and decree, and they'll have a judgment on their record. And the truth of the matter is that in most cases, if a person's only income is from Social Security, that income cannot be taken to pay a consumer debt. Their income is protected. Now, I don't want people to ignore this without calling us. We need to be able to evaluate the kind of debt. But I tell people my short answer is we don't want people throwing good money after bad. If you are, a lot of times people will try and make that extra $50 or $75 payment on a big debt that just keeps, once it's in collections, it's almost impossible to get out from underneath it. And then people end up not buying food, not buying medicine, and falling behind on really basic needs. So we don't want them throwing good money after bad. And Carl and I will both tell you that it's just, people are embarrassed, they're stressed, they're worried, they're not going to get thrown in jail. Nobody can kick them out of their house. Nobody can foreclose on their house. They can't evict them. They can't do any of the things that feel like it's this horrible, legal, scary thing. Consumer debt is not, you cannot take Social Security income to do that. That said, the debt may matter in the next life, but not to that person. And so we just really want to let people know that if you have any questions about it, if you discover that your loved one has a debt that they are struggling to make these goofy payments on and it's just a black hole, call us. And then the last one is consumer fraud and complaints. So the federal law has consumer protection laws that prevent people or prevent lying and misrepresentation of goods and services. And the easiest example that I can think of is door-to-door security system sales. So there, as a matter of fact, we've had so many clients who have been duped by one particular guy who was fired from one security company, and then he signed up with another security company. This is a local guy. And he went around to all of his old clients and said, hey, we're doing an upgrade. It wasn't an upgrade. It was a completely different second contract. And he told lies and did not follow the law. But we now have seniors that are paying for 2 security systems when they probably didn't even need the first one. So if you know anybody that is facing that, have them give us a call. The last one is family law. We cover a lot of different family law at Legal Aid and assist people in a lot of ways. But what I want to focus on here is harassment restraining orders and orders for protection, which are very similar legally. The difference doesn't really matter here. But an example of a harassment restraining orders that we have done and used for people recently are when a senior or a disabled person becomes essentially an involuntary landlord. So the person may need help with tasks at home. So they decide, hey, you, family friend, nephew, uncle, can live with me and help me mow the lawn and check the mail and buy groceries or whatever. And you can live here for free. And what ends up happening is that the situation can sometimes devolve into one where it gets dangerous. The tenant, even though there's a verbal lease here, which is a separate legal question, but the tenant, the client is an involuntary landlord, and the tenant becomes yelling, abusive, can cause property damage. We had one client where her alcoholic brother was way more alcoholic than she realized. He was chronically alcoholic, and he was terrifying to her, and he caused a lot of property damage and things like that. We were able to get a harassment restraining order against him. And those go a lot faster than trying to evict someone. So that's the value of talking to an attorney is, so what's my best legal option here? Clearly there's something going wrong, but what's my best legal option? We had another client who was really sick with cancer, needed a lot of rest, and he had a roommate who was supposed to be helping, and she was up all night with loud music. She had her own set of mental health challenges, but the loud music and the resting for cancer were not compatible. So we were able to get her out also. Legal Aid we try not to be in the business of having people lose their housing, but in cases like this, that's the right thing to do. So that's an example of how we can use family. It's family law, but it's a harassment restraining order. And then finally, this is my last slide. I think, wait, no, well then Carla's slide. We also do referrals. So if we are not able to take your case for whatever reason, lawhelpmn.org is a website that's maintained by all of the legal aid nonprofits that cover Minnesota. Not just us in central Minnesota, but everybody. If you call us and we send you a fact sheet, it probably came from this website. So I really recommend that everybody write lawhelpmn.org down. It's an excellent tool written in non-legal language. There are tools on there to fill out forms online. And it's not going to give you legal advice about your specific situation. It's not a substitute for a phone call to us, but it's a terrific, terrific resource. Even after you've talked to us, we may say go back to Law Help MN and look exactly here, here, and here. And I also tell people that it's a lot more reliable than Google or the dude at the end of the bar. Another terrific resource is Senior Linkage Line. Shout out again, that resource, they're in the business of connecting people to more resources. And we get we get referrals from Senior Linkage when somebody started calling there and they're like, whoa, this is clearly a legal problem. Let's talk to legal aid. The Minnesota Lawyer Referral and Information Services is a long way of saying the Minnesota Bar Association. So they have, that's another place where we can refer people to because it covers a lot of every area of law in Minnesota. The Volunteer Attorney Program is another, what it says, attorneys in private practice who set aside some of their time to help people who can't afford attorneys. They provide their services volunteer. The Latin word is pro bono, but we call it volunteer program. The Ombudsman is the Office of the Ombudsman for Long-Term Care has a number of ombudsmen and women who cover the entire state of Minnesota. They're highly trained and experienced social workers, and their job is to respond to complaints from people who have concerns about the quality of care that they're receiving at a long-term care facility. I love my job. That would be a hard job, but the ombudsmen are amazing, and they're able to they make on-site visits. They're able to step in and help a person who is at that facility and has concerns and listen and work together to resolve what the issue is. It may require some legal stuff on the side, so we work a lot with ombudsmen. To file a complaint about a long-term care or assisted living facility, the Office of Health Facility Complaints at the state of Minnesota is the place to go. There's another nonprofit in Minnesota called the Minnesota Elder Justice Center. And they have a bunch of different legal resources. I didn't write the word down, so now I'm blanking on it. But elder abuse they have a lot of resources about if you suspect that somebody is being taken advantage of or needs a legal angle on their abuse, the Elder Justice Center is the place to go. And then Volunteers of America, Estate and Elder Law Services. So Volunteers of America has an office in the Twin Cities, and they focus on helping low-income and moderate-income seniors with their estate planning services. Again, simple things. If you have enough money to need to set up a trust, then we advise you to hire a private attorney. So those are the places that we refer people to. And then the last thing, it didn't make it, or it got pulled out of the slideshow because it was my boss who's not here. So I'm just going to dictate to you. And there's also some brochures in the back But our phone number is 320-253-0121. I am not Carla. I am Carla's, one of the 3 people that cover all 14 counties. I am a legal assistant and a paralegal. So my name is Chris, Chris.
Back to the medical portion. What is the reason that the hospital would put somebody in observation as opposed to inpatient?
It has to do with their medical condition, how severe it is, how much monitoring it needs. I'm not a physician, so on the inside of exactly what to say or not say, I'm not sure. I'm looking at Dr. Zook here like, Pardon? Sometimes insurance decides. He said physicians sometimes have no control over it. But we do suggest that if what the person is going to the ER for and why they go to the hospital, don't just leave it at that. If the person if there's a lot more to that medical story besides what they were admitted for, that may make the doctors dig further and determine that this person should stay longer and get admitted so that they can their other conditions can be monitored and stabilized before they're discharged to nursing for rehab. Okay? So I can't give you a one-size-fits-all answer, and thank you, Dr. Zook.
Do you have a question? I'm right here.
What is the changing environment, the legal environment, as dementia becomes a larger problem? What's the changing legal environment for dementia as a medical condition?
Ooh, I'm going to say that I'm not an attorney, so for me to opine about changes in the law that are coming or the environment, I can't really say. I will tell you that the tools that we've chosen to talk about, because what I talked about was, a fraction of all of the things that we do. There are tools available to help people plan, and there are tools available to help people get accommodations for their disability and their medical conditions, including dementia. So we want people to use the tools that we have. I'm not sure what is on the horizon. Not that I know of, but I'm not prepared to answer that. So I can't say, no, there's no case law. I'm not an attorney, I'm sorry.
So as a physician, that idea of being admitted or just under observation is a huge issue of all these things that's glaring to me. And you can be in the hospital for 3 or 4 days and find out that you weren't admitted, which is mysterious to doctors. We have no idea. And I'm not sure who makes the decision, but it's not me when I was admitting. That's been a few years, but it's very disconcerting. And I think if they do give you a paper, when you're upset and your loved one needs to be in the hospital, who thinks about the legalese with the papers? You sign anything to get them upstairs and taken care of. It's duress. You're signing that under duress. I agree. The other thing when you're not admitted is you may have to provide your own medication. If you're not admitted, if you're only under observation, except for intravenous medication, you may have to provide your own pills for your blood pressure pills, your diabetic pills. It's a big deal. So if your loved one is at the crux of admission, what you think is admission, ask them about the ramifications. Am I going to be under observation? Is my loved one going to be admitted? And what does that mean? And it's just really not fair.
And we can just say from experience that after the fact, it's really hard to argue. So, Dr. Zook is on the front line at the hospital, and then we get this a month later, and it's like, So that's why I am encouraging, I don't have a magic wand, but to the extent that you can paint a picture of all of the conditions that your loved one has that may need to be monitored and stabilized before they're discharged for rehab, that's what we advise.
Question here?
Yeah.
It's been a while since I worked at the hospital, but I remember that situation, and it was like overwhelming. But generally, there's somebody from the business office, quality care, that would issue this letter so that you would know that you were under observation. And at that time, you present your case, and then you ask that person to please present more information to the physician. The physician has to be documenting more things about why they think you should be admitted. I mean, it happened, and it was very, very stressful.
Thank you.
Anyone else? I have one thing that I want to mention, and having just gone through the loss of my mother, I was aware of this, but a lot of people don't realize that power of attorney ends when the person dies, and then
Yes.
they're locked out of the finances and stuff like that. I don't know why that isn't widely known.
I thank you very much. I forgot to say that. It does end when a person dies. And so the question then is, well, do I need a will? And I'm gonna say that legal aid does not do wills. We leave that to attorneys in private practice, and there's one coming after lunch. But not everybody needs a will either. If a person has very limited assets, no real estate, limited income, and they're able to, here's who should get payable on death for this policy, transfer on death deed, have those things in place, they may not need a will. But power of attorney ends when a person dies, so having a plan for afterwards, one way or another, is important. Yes.
Anybody else? We got another question here. I feel like Phil Donahue.
Did you also say that having the power of attorney, if the person becomes incapacitated, that no longer applies?
No, it does. There's an option to choose if you want it to continue after you lose capacity. And I have not had a client say, I want it to end at capacity. The Minnesota form allows you some flexibility about what choices you want. And the only reason that a person would say, I want this power of attorney to end after I lose capacity is because I have another much more complex legal arrangement over here. But I haven't met anybody like that.
So what's the springing power of attorney? They use the word springing, POA?
I am not familiar with that.
Okay, never mind.
That's okay. Sometimes people say a durable power of attorney, and to me that means a power of attorney where the principal has checked the box, I want this to continue after I lose capacity.
Answer?
Yeah. So if you were writing a will, you would have a durable power of attorney that continues after you're dead.
No, it continues after you lose capacity.
Oh, what's the name of the person who continues with your financial things that makes decisions for you? Is there?
That's the attorney in fact. So the power of attorney is the name of the document. The principal is the person who has the assets, the bank accounts, and the stuff. The principal, through a power of attorney document, names an attorney in fact. And that is the person who gets the power to handle the principal's legal, financial, and business affairs. A lot of times we just use power of attorney to cover all three of those. The principal who has a power of attorney document in place, the document itself, and the attorney in fact. Sometimes people say, I'm the power of attorney. Well, I have the power of attorney. I'm an attorney in fact. I'm not going to. That's splitting legal hairs. The big takeaway is it does not continue after death. But it can continue after a person loses capacity, and as soon as it's signed, it is legal. So there's also a real caution. I advise clients they really need to trust who it is that they're naming as their attorney in fact, because it's not a supervised power. That person could take money from the bank account and go to Vegas. And that's it. If it turns out that there's a high level of fraud or other things like that, you can turn around and start perhaps a lawsuit, but it's not supervised. So there really needs to be a high level of trust.
When they have identified a trustee, does that fall under the power of attorney? Is that the same thing as a principal?
A trustee, I think, is related to a trust, and we don't do trusts. That's a completely separate legal instrument. I would save that question for the person after lunch.
Ms. Molly, thank you so much.
So in terms of if somebody has power of attorney, they die, what do you need to have set up so you can still have access to bank accounts, et cetera?
It depends. One of the things that we advise people to have is that you have a payable on death designation, essentially for all of your assets. And whether this is wise and who you choose and whether that makes sense in the larger scheme of your estate planning, I can't comment on that. But I can tell you that the tool that you would use to list your bank account is, and hopefully we all have done this, right? You open a bank account and they ask you when you open it, they're like, so who should get the money if you die? Just make sure that's up to date.
Also, I will say that my mom and I had gone into the bank and just filled out a TOD or something.
Yep.
So that was taken care of. Yeah.
Payable on death, transfer on death. Yep. So the big takeaway there is just make sure that those documents are up to date and that the person named is still who you want, that they're around, that they haven't died, that it isn't blank. Make sure those basic things are in place.
I think we
Amanda?
well.
Oh yeah.
I know you've been standing there. Can we do one more question or two? Okay.
The other thing is just also be on the account of that person. So, for example, I was on my mother's credit cards. I ran her checking account, all those kinds of things. And so
sure. That's another way to do it. And that's a more limited way to give somebody the power to handle business and financial affairs. It's limited to whatever you specify and put their name on. So we've had clients who inherit property from some long-lost relative, or they're getting ready to qualify to get county assistance for the nursing home, and they discover that they've got an old savings account from a woman before she was married, when she had her career. She now has advanced dementia. And there's no person named on that account, but the money's in her name and it's needed to pay down her nursing home care. So we actually ended up getting guardianship for her husband to liberate $12,000 or something like that. It was so if you have a really good idea about all of the assets that a person has and you want to add somebody's name to them, you can do that. The difference is a power of attorney is broad and it allows for power to handle things that you haven't foreseen yet that might show up. So I'm not saying it's a bad idea. It's a great idea. It enables you to give a person or divide up who's responsible for this account or that account among your loved ones. There are choices. Yeah.
Just one more question.
You mentioned the Minnesota power of attorney form. If you move to a different state, is it necessary to get a new power of attorney form filled out for that state?
You should not. If you move to a different state, it's probably worth asking one of those things and say, I have this power of attorney form in Minnesota. Do I need to redo it? Because I can't really comment on other state law. I know that Minnesota recognizes power of attorney from other states. But such is our legal system. There's a lot, you can only be admitted to the bar in one state at a time, so. That's about
All
it.
right,
Yep.
thank you very much. It sounds like we could go on a lot longer. Chris Klimpel, everybody, please.
Thank you, everybody. Nice to meet you all.
Nice hand.